Well, let's see what we have here. Looks very official. So it appears that I'm being sued. Now this is going to happen to you at least a few times in your medical career. You're going to be sued either as a larger group or individually. And since it's unavoidable, you should probably at least be prepared. So over the next series of videos, I'm going to walk you through the essential elements of a lawsuit so you know what to expect and also what to do. So what is a statement of claim? A statement of claim essentially starts the lawsuit. Because it is a legal document, it is long and complicated, so try not to get lost while you're reading it. The first part is called the style of cause. It is a very long list of all of the people, including yourself, the hospital, and other services that were involved in this patient's care. This list is necessary since the suing lawyer really only gets one shot at naming all of the relevant people. The list must be drawn up before all of the details of the case are known, which may not be until well into the questioning phase. Often you're going to get dragged into a lawsuit simply because your name is on the chart and you may not even be directly involved in the event that led to the lawsuit. Now, the second part of the statement of claims is all of the facts that form the basis of the claim. Now, it's important to remember that these facts are based on what the patient told the lawyer and may not be accurate or may be incomplete. It's definitely not the whole history of the patient's care, but essentially sets the stage and tells the story from the patient's point of view. So you don't really worry too much if there are some of these details that are missing. The next part is usually the worst part to read because it lists what they think you did wrong. This is the part that makes you feel like you're the world's worst doctor. You probably see the lawyer shouting something like, "We have to put a stop to this madness. They must be made to pay for this outrage." That's just simply not the case. The final part of the statement of claim is the damages, or the money that they want from you. The lawyer basically lays out all the costs that they expect to incur as a result of your alleged negligence. In a sense, it's almost like an invoice, usually a really, really grossly inflated invoice. But if you want to write a check for the amount, then they will take it and they can make this whole thing go away very quickly. But I wouldn't suggest doing that without talking to someone. Seriously, don't just write a check. On the last page of your statement of claims, tells you what to do next. You are on a very tight time frame and the clock is ticking. You can only stop the clock from ticking by talking to CMPA, since they need to be involved because only lawyers can stop the clock, and it has to be by agreement between your lawyer and their lawyers. So call CMPA as soon as possible. They're going to guide you. Most lawsuits are for negligence, so let's just focus on that for today. In law, there are 4 elements that must be proved for the lawsuit to proceed. First, the physician must have owed a duty of care to the patient. The physician must have breached the duty of care. In your case, this means the standard of care. Third, the patient must have suffered an injury or loss. And finally, 4, the physician's conduct must have been the actual and legal cause of the patient's injuries. So now let's explore these elements in a lot more detail. First one is the duty of care. Now the duty of care starts the moment there is a doctor-patient relationship. This is the promise that the physician will act responsibly and in the patient's best interest. This is the promise we make with society as professionals. This component of the lawsuit is usually not disputed. Basically, any patient you meet or are involved with in any capacity, you owe a duty of care to. This even includes night coverage, even if the patient just happens to be on your list and you slept all night. The only case I'm aware of where no duty of care existed was when a rheumatologist in a different city was sued by an obstetrical patient, simply because he had the same name as the gynecologist she was aiming for. The rheumatologist and the patient had never met, and so there was no duty of care. The standard of care is the most important component in a negligence lawsuit. Deciding if the physician has breached the standard of care is often where most of the energy in a lawsuit is spent. Now, no matter who you are, the law requires that in all circumstances, you don't expose anyone to unreasonable risk of harm. Even in your private life, you can't drive recklessly and expect not to be sued if you hurt someone. And similarly, if you're reckless in your medical care, you can also expect to be sued. The standards physicians are held to is called the reasonable physician standard. This is not the perfect, smartest, bestest physician in the world standard, but rather represents the reasonable physician who is similarly trained and experienced. In a sense, if another physician like you would do the same as you, then likely you met the standard of care. Now, the third element is that the patient must have suffered an injury. This might seem pretty obvious to you, but it's still an important element of the lawsuit. Suppose a resident perforates a bowel during surgery, causing the attending surgeon to take over, repair the damage before continuing the rest of the operation successfully. Now, the resident owed a duty of care to the patient. The resident breached that standard of care as the patient's bowels should not be perforated during surgery. But the patient suffered no injury since the perforation was repaired quickly and without any complications, so the patient will not be able to win this lawsuit. Now, it's usually obvious that there is an injury, as most patients would never ever consider going through the hassles of a lawsuit when they didn't suffer any real loss. Similarly, their lawyer will likely not be interested in helping them, given the fact that if there's no loss, there's no lawsuit, then there's no money. Now, the final element is that the injury was caused by the physician's negligence. The legal principle applied here is called the but-for test. Now, you're probably asking yourself, what's a but-for? Pooping, obviously. This test asks the question whether the injury would not have occurred but for the physician's actions. Now, an example of no causation would be when a patient presents with pneumonia but is incorrectly diagnosed with a stubbed toe. The next day, the patient dies from a subarachnoid hemorrhage. The misdiagnosis of the stubbed toe would not meet the standard of care, and the patient has suffered an injury. But the pneumonia is not the cause of the patient's death, since there's no relationship between the two problems, the pneumonia and the subarachnoid hemorrhage. The statement, but for the erroneous diagnosis of a stubbed toe, the patient would not have died from a subarachnoid hemorrhage, makes no sense in any way. On the flip side, if the patient had in fact died from septic shock from the pneumonia, then causation could easily be shown. The statement, but for the erroneous stubbed toe diagnosis, the patient would not have died from septic shock due to the pneumonia, makes perfect sense. Now, you're probably saying to yourself, this is all very interesting, but I have a very scary document in my hand, and I need to know what to do next. You need to understand that when you get the letter, you're going to have all kinds of emotional reactions. This is normal. First thing you need to do is take a deep breath. You are not a bad doctor, and this is not the end of the world. This is going to happen to all of us eventually, and the problem is we don't talk about it openly, which leads to fear and isolation. Personally, I think we should be talking more about this so that we all know that this is normal. You don't have to speak specifically about the case you're involved in, but at least saying that you're involved in a lawsuit and are stressed can go a long ways in helping people support you. But let's put some things into perspective here. A lawsuit can take well over 4 years to be resolved, and ultimately you can expect that you're only spending about 12 hours of those 4 years involved in any activity around it. So don't let it take up too much space in your head. First thing you need to do is call the CMPA. And when you call the CMPA, you will first speak to a physician advisor who will guide you through the next steps. They will also provide you literature to explain the process and have other resources to assist you during this stressful process. Soon afterwards, a lawyer is going to contact you. This person is your advocate. It is absolutely critical that you follow both CMPA and your lawyer's advice. They are trying to help you, so don't make it hard on them. Now, when you are first served with a statement of claim, your thoughts are going to be to go look up the patient's medical record. Resist this temptation. Depending on your province, you may actually run afoul of privacy laws. Take your lawyer's advice. They will tell you when and how to access the medical records. Generally, the lawyer will obtain a copy of the chart and then provide that copy to you for you to review. And finally, the last thing you need to do is try to relax. You are not a bad doctor, and it's entirely possible that the lawyer who sued you doesn't think you're a bad doctor either. You may be just a name on a chart. They may even know that you're not a bad doctor, but included you because, well, they have to. Remember, lawyers are professionals paid to do a job. Just as your job is to care for patients and place their needs above all others, a lawyer's job is to represent their client and defend their interests above all others. You may not agree with your patient's decisions, but you still take care of them. A lawyer is in the same way, may not always agree with their client, but they still represent them. Lawyers and doctors may be different, but we are both professionals. This is the textbook for medical malpractice for lawyers. While I was reading it, one thing I was really struck by was the deep respect that the legal profession has for the medical profession. So, as a fellow professional, we owe it to them to reciprocate by understanding the process and respecting their role in it. Next time, we're going to cover your response to the statement of claims, the statement of defense. Until next time.